what was here in this case. Whether distributors of peer-to-peer file sharing software would be held liable for a copyright infringement. That was the question under consideration. Whether distributors of peer-to-peer file sharing software. So obviously this Grokster, it is a privately owned software company. It was in it is a West Indies based company, and it is like responsible. What was the product? Peer-to-peer file sharing, like the software. Okay, and it was like very fast transfer is there. Okay, so as we have seen that Sony case 1980s case, Napster case was 2001, and this case is a 2005 case. US District Court for Central District California originally dismissed the case in 2003, citing Sony's precedent. Device is allowed, right? They are not liable for copyright infringement. So considering that, this case was dismissed. Appeal in Ninth Circuit Court. So it again upheld the district court's decision after acknowledging that peer-to-peer software has a legitimate and a legal usage. Now in this case, that amicus curiae, considering that particular, we can say, the aspect of a law, many other parties involved. Okay, so amicus curiae is like a friend of a court. In short, if you see what it is, that individuals or organizations which are not party for that legal case, but they are permitted to assist the court. So here in this case, you can just check here. So here you can just check that few parties which are there. You can just check here that Intel and Yahoo, they were with a Grokster. Now what they have, Intel and Yahoo, that computer and internet technology companies, they says obviously that Intel and Yahoo and all, they says that they have in support that file sharing companies, that is this Grokster. But this two like a Recording Industry Association of America, that is RIAA, and this Motion Picture Association of America, that is MPAA, you can just check here, they were in favor of MGM and other entertainment companies. And Napster also was given the Napster was also there, and what was the statement given is like having obviously the case we have seen that enabling of users copyright infringement, filed a brief in support of entertainment companies. So again Napster was in favor of MGM. Again Mark Cuban. So Mark Cuban is he supported Grokster for a legal battle. So you probably have seen in Shark Tank that the outcome was that US Supreme Court ruled that companies can be held liable for inducing copyright infringement. So here this software is help for the sharing, right? So what the statement was, companies can be held liable for inducing copyright infringement. And Grokster, obviously what happened, the decision was again against Grokster, and what was the statement used? We hold that the one who distributes a device with the object of promoting its use to infringe copyright as shown by a clear expression or other affirmative steps taken to foster infringement is liable for the resulting acts of infringement by a third parties.